So as I mentioned at the outset, we really do have a packed agenda over the next couple of days, and we're extraordinarily fortunate to have the opportunity to have many of the people on the front lines making the decisions and hopefully answering some of the questions posed not just in our first panel, but really throughout the week. And really, I guess there's no one who's more at the center of things nowadays than Bill Hinman from the SEC's Division of Corporate Finance. And I also want to thank you for taking the time to listen to the earlier panel to help provide us with a bridge of sorts into this discussion. I thought the first panel was surprising in part because there was a little bit more pessimism, for sure, in that panel, in particular as it related to nomenclature, but also the developments in the industry. I wanted to get your views first as to your perception of the industry, of the crypto industry. What exactly excites you, not just about the crypto industry more generally, but about blockchain more specifically, and what concerns you from your perch over at the SEC?
Sure. Well, first, Chris, thanks very much for having us here today. The SEC gets a lot out of these kinds of discussions. I hope we have enough time at the end. We only have half an hour, so we're going to be kind of tight on time. But for some questions from the audience, just so I can hear what's on folks' minds. Before I go any further, I should say that the comments I'll make today are my own, not those of the commissioner or any other staff members. And in terms of what's going on, we see obviously a lot of activity. I joined the SEC about 1.5 years ago, and this area was just starting to, at that time, in terms of the regulators' focus, become more in focus, and it was clear we needed to spend more time on this. There were some members of the staff who had been up to their elbows in this for some time, but it wasn't generally well understood across the agency what was going on in the digital asset space. But very quickly, we got a team together and focused, and today that team is headed by Val Sapanik, who is a senior advisor to me for all of the fintech work that we are doing. And she has over 5 years experience, in this particular area and over 20 years experience at the SEC, very seasoned, very well known in the digital asset community, and I think highly regarded, and a terrific person to help us focus our efforts across all the divisions. I'm the director of the corporation, the Division of Corporation Finance. The Division of Corporation Finance generally regulates offerings of securities and exempt security offerings. We sort of administer that space. As such, we have a pretty heavy responsibility to sort of determine, is something a security offering? And so very early on, after Jay Clayton became the chairman and I joined him, we focused on how do we message out to the world our thoughts on this. And the first opportunity we had was the Dow, what we call a 21A report. It's usually done in conjunction with a couple of divisions, enforcement and us in this case, IM also, to sort of articulate when do we see a digital asset offering as potentially a securities offering. In that case, investors hadn't been harmed significantly. We knew it was an early move, and so we decided to use a 21A where we don't enforce, adopt sanctions or penalties. But it was a way to get out to the market some of our thinking. The crux of that was we are going to be looking at these instruments and the way they are offered through the lens of the Howey case. Although the Howey case is 70 years old, it's still, as a principled base bit of guidance, it works very well. And it's obviously been applied consistently and defined over time. And I think if you look at Howey and its progeny, including Gary Plastics, you have a pretty good sense of how the SEC will view a transaction in any investment contract or any offering, whether it's a digital asset or, in the Howey case, an Orange Grove interest. And so we kind of tried to get that out there. We also, last summer, spoke a little bit more about how we were looking at some of the more decentralized and seasoned digital assets like Bitcoin and Ether on the Ethereum network. And we made it very clear that at this point we don't see a reason to regulate those as securities or transactions in those instruments as securities at this point. I know we're going to get into more detail on this, but that was another part of our exercise in terms of making it clear to the market how we look at these instruments. And then quite recently, we have sort of restructured our fintech group with Val again being the head. And one of the things that we're trying to do there is make it easier for people to get feedback from us. So there's a formal intake form. It will be the place you would go to coordinate across the divisions. Many times the questions that come up involve investment management, trading and markets, corp fin, potentially enforcement. And Val, through that group, will sort of centralize our guidance. We also will be putting out more guidance. The idea is a plain English instrument that people can look at, and it will bring together sort of my Howie meets Gary speech and that analysis, the Howie and Gary Plastics case analysis, and it will elaborate on that in a very plain English way. So, do I think I have a security offering? Look at that new guidance, and I think you should be able to sort this out. If it's unclear after going through that guidance, there's going to be a very easy way to reach us and get more guidance directly from us. Once you determine whether you have a security, we're going to have in that guidance, how do I go about registering it, and how do I go about doing an exempt offering. Right now, we do have a number of draft registration statements and Reg 1A confidential filings where people want to come in and do something with an asset, a coin of some sort. And we're seeing a pattern to the comments that we typically give. It's been a slow-going process. There are tough accounting issues. There's tough custody issues. There's sometimes valuation issues. There's a whole host of things. And I think we can try to bring that together and sort of share that, because the folks that we're talking to right now are doing it in a confidential process. So the world's not seeing some of the things we're focused on. So we want to share that a little bit more transparently. And so you'll see there, like how do we view the white paper? That people may have used in the context of either a registered or an exempt offering. So registered or exempt. And then we'll look at secondary market transactions. That will be done more by our colleagues in trading and markets, but we'll give people a sense of things to think about in that space.
So do you view your role at this point in time as cleaning up some of the ambiguity that's in the market, or applying long-held sort of established concepts in a way that's consistent enough to provide predictability for both entrepreneurs and investors? We'd heard in the earlier panel that even when people were sort of creating these products, founders, creators weren't always quite literally on the same white page as others, which leads or has led to at least some confusion on key terms like decentralization, which in the context of the Howey test can have a very real impact on whether or not the commonality prong, for example, is met or not. I mean, so do you view your work and your job as not just providing clarity as to the SEC's position, but also helping to establish common a lingua franca for those in the market?
Yeah, I don't see us having sort of the lead role in working out the vocabulary issues here. For us, the regulation of a particular offering of an instrument is going to be principles-based, and so we've been trying to make that very clear. And the principles are really the ones that were articulated, again, in Howey. And so, if someone's offering an instrument for money or other consideration to a third party, and that third party expects the offeror to generate a return or do something that will increase the value of that instrument that they purchased, whether it's a coin or a token or whatever they want to call it, and there's that expectation of return, we're generally going to see that as a securities offering. The chairman very famously said he hadn't seen an ICO that wasn't a securities offering. I think people are sort of getting that. If you're raising money, people are giving you money and they're expecting some sort of return on it, not just the utility of the token, which is then usable and can be exchanged for its original purpose. If people are doing that, there's going to be a role generally for the securities laws, because that person raising the funds will know a lot more about the prospects of what they're doing, where they are in the stage of development, whether this is a highly risky idea, whether they have the right talent already assembled to make that idea work, where they are in that process. All these things that we refer to as information asymmetries. And if we see a high level of information asymmetry and we see a central party raising the funds there's generally a role there for the securities laws to protect the folks that are buying that instrument, who have some expectation of that third party. So it's very principle-based. We do think we've cleared that up. I think most people generally understand when they're doing an ICO that they have to be worried about how the securities laws will operate. We meet with industry participants at least once or twice a week. We do have folks who are handling this very responsibly, coming in, want to have a deal that they know the SEC has reviewed. So we do provide that kind of guidance, but we are not. We participate in forums. We participate in the IOSCO meetings. We participate through the Treasury's working group among all the regulators on this space. And in those groups, we all work through the vocabulary issues, mainly so we are all talking about the same thing. But in terms of thinking about the securities laws, it's kind of surprising that the principles that were articulated many years ago seem to continue to work pretty well.
Great. Amongst those principles, and again, this is just one last vocabulary-related issue, and then we'll get to some broader 10,000-foot principles that you've articulated during your tenure. But we had talked about decentralization in the last panel. You've made remarks, as well as others over at the SEC, about examining, perhaps after the fact, or how decentralized particular offerings are as one consideration, amongst others, in determining when and under what circumstances a security or investment contract arises. When you look at the crypto asset space, what other kinds of considerations do you believe are either a twist on traditional fact circumstances that have come before the Commission, or are particularly salient for identifying an investment contract that really needs to be either registered or meet some kind of exemption under and by the SEC? Right.
So decentralization, to a certain extent, is important. It's another way to think about that information asymmetry question. If something is out there and there's a broad-based governance system, the developers communicate through GitHub or Reddit, and there's no one person sort of driving the process. It's highly decentralized. There's a service that's available on the network that works, an Ethereum kind of basic service that people can acquire with their coin. Then those are all important. There's a host of factors. And one of the things that we've been sort of communicating to the people that come in and meet with us, and they are communicating back to us, is that folks are starting to discover that it may be easier to do the early days of funding in a more conventional way, where you're not offering the token, where you get the network and the service up and running. And then after that, it's much easier to put a token on top of that. Now, I totally appreciate that. A lot of times the buzz of an offering, getting in on the ground floor and all that can be very valuable to generate an interest in a project. And the blockchain has a lot of interesting, exciting projects. But to the extent you can introduce the coin later in the process, it's so much easier to do it in a way where, if you're intent on not having it be deemed a securities offering, where that will be easier to accomplish. You can point to the service or the good or whatever that is then available. Someone is much more likely to buy it for that purpose as opposed to looking for an investment return. You can have it trade in increments that are not investment-like increments. It could degrade in value over time, because if it's just a Chuck E. Cheese coin, to use the very simple analysis, and it degrades over time, you're likely going to use it as opposed to hold it for investment. So there's lots of things that can be done at that stage, and we're seeing a lot of the more sophisticated venture funds start to guide their clients a little bit along those lines. It does make it easier. The other thing that's happening is a lot of the buzz of an ICO and the charm or the excitement you might generate by that has kind of come off the bloom. If you look at, I don't know if you're going to have anyone from E&Y in the conference, but E&Y just put out a very interesting study about a week or so ago looking at the class of 17 ICO performance. And it was, you said things were kind of discouraging in the first panel. If E&Y were speaking about their report, that'd be very discouraging. The performance, I think on average is down 66%. If you look at all of the offerings, only the top 10 are generating any kind of positive return. There are a number of instances where people haven't been able to produce a product or any kind of service at this stage. It's still early, so maybe that's not fair. But you look at that report, and it was not a particularly optimistic or cheery report. And I think what that does is it makes people a little bit more realistic in this space. And so if you want to fund a new great idea on the blockchain, you'll look at other ways of doing it. It won't necessarily be through a white paper ICO.
You had mentioned in June you had made a speech with, to quite a bit of fanfare. It was well received. And I think it's worth repeating even here to this audience a couple of those main principles. I know there are also a number of folks both in the venture VC community as well as entrepreneurs. And it's always good, I tell them, to listen to people who are actively crafting the rules for this work. And maybe you could repeat a couple of the 10,000 foot
Sure.
ideas.
I mean, the speech got a lot of attention because it was the first time we had expressed to the world that we didn't view Ether as a security as it was then currently being offered. We're not talking about the original offering, and we're not talking about what it may evolve to over time or if someone repackages it or does other things with Ether. But we're saying at the current time there wasn't really a need to regulate Ether as a security in our minds. The speech was called When Howie Met Gary because of those two cases. The Howie case we've talked about. The Gary Plastics case was a case involving a CD, a certificate of deposit. And by statute, certificates of deposit are declared not to be subject to securities regulation. But in the Gary Plastic case, a CD was. And it was because it was repackaged and offered in a way where the broker was adding some services and creating an expectation from the folks that were buying the CDs from them that they would do more to that CD and give them a better return. So we titled it that because it sort of illustrates the point. Regardless of what you call something, a token or whatever, we're going to look at it on a principles basis. And so a CD, which is by statute not a security, could be a security. A token, just because you call it a token, doesn't mean it is a security or it's not a security. You have to look at the circumstances around the way it's being sold and what people are expecting when they purchase it.
One of the things that I'm sure you've heard and others will say is that the Howey test is great. Insofar as providing these principles. I had a discussion just last night with a high-level international visitor in which I tried to explain that the Howey test is more than just a test that students in my securities law class memorize in terms of the prongs, but there are principles behind each of those prongs, information asymmetries and the like, that when collectively together they rise to a degree to which the SEC feels that it needs to sort of step in. One of the responses is obviously, well, if you have an ad hoc test, a situation by situation test, there's not enough regulatory certainty, and we're going to see a flight of these transactions overseas. What do you feel about the prospect of international arbitrage, cross-border regulatory arbitrage? Is the Howey test instructive enough to provide sufficient comfort and certainty for those who are transacting in this environment in order to develop it? What's your view on it?
Yeah, I don't think the Howey test is that hard, right? And I don't think it's that
Tell
hard.
my 2Ls.
Yeah, well, they're 2Ls, but there's a lot of sophisticated counsel in the room. I think they could sort that out. People that are fleeing this jurisdiction because they want to do something somewhere else where their ICO won't be as regulated, I don't think it's because they're lacking definition. I mean, it may be that now that there is more definition, it's a little clearer that you can get yourself sideways with us or others if you are offering a security. The U.S. securities markets are one of our jewels. The reputation for transparency, the quality of the disclosure, the system that we have. I mean, obviously there are issues that come up from time to time, but I think it's fairly well recognized that our capital markets work well. one of the reasons I think we pulled through the 2008 recession a little faster than maybe some of our colleagues overseas, were the flexibility and the strength of those securities markets. So we're not about to compromise those to view ourselves as a safe haven for something that looks like a security and feels like a security and say, oh, but we don't need to regulate it as such.
One of my responses was also that other jurisdictions aren't always as certain as they claim to be, and you have lots of challenges there.
Yeah, well, one of the things that we do see when we do participate in IOSCO and other sort of international fora is that they are quite interested in how we've approached the space, and I think people have felt like we hadn't acted too quickly, and the steps we're taking seem reasonable to them. So lots of people are curious about how we've done it, and we're seeing more uniformity around how this area is approached.
Great. I'm about to open it up to, I know what are some questions in the crowd. I did want to end with one very last question. Do you have a sense that, to the extent to which you're moving into a more regulated crypto asset space, where perhaps you'll have one day a registered ICO and even more privately placed ICOs under established guidelines, are there, to the extent to which you think about disclosure, are there any particularly either interesting or quirky aspects of disclosure that the commission's going to have to tackle, or the industry, just given the nature of a crypto asset, like blockchain governance, or are there any kinds of issues that are percolating that you can share with us that you think are going to be a matter of real interest?
Yeah, I think the custody issues have been pretty important to date, and I think we're getting much closer to having some guidance out there for the industry that wants to custody these. So, broker-dealers and other institutional investors want to have a better sense of what do they need to do to safeguard these assets in accordance with the regulations they need to comply with. So custody is something where there'll be more guidance, and I think a key issue. To the extent the token is in any way tied to the value of other digital assets, the valuation issues are always important. The accounting issues are very important. The accounting issues actually kind of tie in with the custody issues, because the accountants have to go out and make sure that the company actually owns the digital assets it says it owns often. And that can be a challenge, or the way that they go about valuing their digital assets when you have very fragmented markets that are not regulated in the same way our securities markets are regulated, and how you establish value. So those are a few of them.
Great. So we have time for just one or two questions if you have them.
Thank you. Nick Carter, Castle Island Ventures. Director Hinman, thank you for your talk. So I work for a venture fund, and we talk to a lot of, let's call them token issuers, that inform me that they are planning on passing the Hinman test, which is maybe an unintended consequence of your talk. But it seems that now we have lots of tokens that are designing against the Ethereum test or the decentralization test, which you described. I wonder what you make of that.
Well, it sounds good. And maybe they are going to follow that path I described before, which is maybe have a more developed network before they offer tokens for funds, which would be terrific, because as I mentioned, I think it is easier if you're a little bit more established and you have something that a network on which your token can operate, to then pass the whatever test to make sure that it's not something people are buying with an expectation of return, where the person offering it, your colleagues, know a lot more about the prospects of the value of that coin than the purchaser of that coin. But again, I think there is a path there. It is somewhat challenging to start your funding and with coin offering and get there. I think if you have a more established network, then there's ways you can build your token and features into your token that make it much less likely to be viewed as a security. Thanks for the question.
But also feel free to get to the aisles if you're close to an aisle, and otherwise we'll try to get a microphone to you.
Really appreciate the comments. I just wanted to make sure I understood one of them that you mentioned, you said that, and I think you were talking around like a stable coin, where you have a coin tied to some other coin for valuation and ensuring that whatever entity has the requisite assets to support what they're saying are the stable coins. Is that what you were talking about at the end, or?
Oh, yeah, when I mentioned that in terms of valuation being an issue, you may have other digital assets that you're holding that become part of the investment thesis. I wasn't so much thinking about a stable coin. I was thinking about different products where people are trying to register a fund basically of 4 or 5 different digital assets that they're going to hold, and then avoid becoming an investment company potentially by not holding too much in the way of securities, but still have an instrument that people are going to say, well, how do I know what the net asset value of this collection of assets may be today? The products in that area, one of the challenges they face is just having a reliable and good measure of the value of what they're holding.
More questions. Feel free to identify yourself. That was Phil Brunner, brilliant venture capitalist.
Getting to regulatory arbitrage.
Your name?
Ryan from Pillsbury.
Thank you.
Getting back to regulatory arbitrage concerns, with the emergence of the Maltese regulations and now France pushing for an ICO-type regulation, is the Commission at all concerned about the kind of arbitrage that surrounds Regulation S, that folks are just going to have sister subsidiaries that are going to do ICO offerings in compliance with those regulations, and then 1 year later, they're just going to flow those securities back into the U.S.?
Yeah, I mean, it's possible that people would potentially try to arbitrage Reg S. As you know, Reg S was reformed 20 years ago to avoid some of the flowback issues. We haven't really seen much of an issue in that space yet. We did have one security that seemed to potentially present those issues, and it was starting to trade in the U.S., but it's no longer because broker-dealers really weren't qualified to trade in it. But yeah, that is a concern that there would be that activity. That's another facts and circumstances test. If someone is offering overseas with the intent that the U.S. market's going to absorb a lot of that demand, then there may be some concerns for us there.
Is the Commission looking at white papers for specific references to U.S. persons?
We often, yes, we look at the white papers for those and other issues.
Great.
Hi, Stephen Dahl with Capital One. At a previous discussion, a audience member asked the question, how do we know we're not applying the same failed regulatory frameworks to this new asset class when referring to the Great Recession? Are there risks in this space that keep you up at night, either to regulate or to not regulate?
Yeah, they don't keep me up at night, but there's been a lot of looking at whether digital assets overall present any sort of systemic risk. The international regulatory bodies have done a lot of that work, and the amount of activity in this space today is being viewed as something that doesn't create systemic risk. We haven't seen a lot of digital assets in the institutional space. Whether over time that could happen, we'll see. Right now, I think there are some regulatory gaps. That's one of the reasons groups like the Treasury meet with all the different regulatory bodies to think about the gaps and how we might fill those things. But right now, I don't see this space presenting a systemic risk. It does present, risk to retail investors, and we've been very concerned about that. That's why our education division has put out, the Howie coin. I don't know if you saw that, but it was a spoof on a token offering. We're doing a lot of investor education in that regard. And we think that's been pretty well received, that people are a little bit more aware that these are not the promised land, that you have to look carefully at this space. And so one of our regulatory goals is to make sure that investors are protected, and we're doing a lot in the investor education front.
And as a program note for you, Sheila Bair will be here in about an hour or two to talk about comparisons between the financial crisis and are there any risks in crypto asset space? And then Craig Phillips will be here from the Treasury Department to talk about crypto assets, FSOC, and financial stability questions. Please. Yeah.
Hi, Donna Riddell. Yes, my class also at Fordham Law School has dissected, like, as if a Talmud interpreters what your speech has. But I wanted to, what I wanted to actually focus on was the fact that in the last number of months, whether it is as a consequence of the evolution of in general, the crypto asset space, or the SEC and the CFTC in combination with each other, the growth of the security tokens, does that shift make it seem to you that in fact we have a lot of innovation going on in the United States and that it's moving much more into a space of regulation that you're more comfortable with and will be with something that will be able to flourish?
Well, I think a lot of the participants in the industry do see some value in the regulatory framework being worked out, and to be able to offer products that do have either an SEC registration behind them, or compliance with the securities rules and the CFTC rules, the FinCEN rules that apply. So I do think there has been a shift to it being starting out as a little bit of the Wild West, to people now saying, yeah, there's some value in people feeling like the instruments that are being offered in this space are being offered responsibly. I know what I'm getting into. I can understand the disclosure. So I think there's value in that. Where we are in that development, it's a little hard to say. It's still early. I mean, the E&Y report is not particularly encouraging. But we very much believe there's a lot of promise in distributed ledger technology, and it's even in the finance space that we deal with frequently, in terms of being able to foster capital formation by being able to track interesting financeable assets like containers or rail cars in a way that would make them much more financeable and easier to track and utilize more effectively if you're putting some of that onto the blockchain. So we think there's a lot of promise there. We think the industry, good parts of the industry, see the value of doing it in a regulated way, or in a way that would give investors more comfort in the space. And so I do think it's still a little bit early days, but I think there's a lot of promise there.
Okay, one more question. Whoever's closest to the microphone.
Thank you. I'm Tony Lau with Fintech for Good. And in the crypto and ICO world, there's a lot of interest recently on STO, security token offering, or tokenization of securities. Right. Does the Commission see a lot of filing or inquiries about STOs? And is this something the Commission welcome?
Sure. I mean, I think one of the things that the blockchain can do is make it much easier to track who owns the security. That can have a lot of value in terms of voting your securities and getting the beneficial owner being able to vote more effectively and track ownership more effectively. So we think tokenization of securities is a good thing generally, and we do have some draft filings would represent that kind of offering. So yeah, that's something we're happy to see.
Great. Thank you so much for these remarks. We will take a very quick break, and then we will jump into Ripple, Lightning Labs, Zcash, other developments shaping the industry. But again, having you here, Director Hinman, was just a real treat. Thank you very much.
Thank you very much. Thank you.